Hi, my name is Buck Kansas. I'm federally licensed to practice patent law. It's been my day job for a number of years now, and there's a recent development in the Pokemon versus Pal World case that I want to talk about. Pokemon was granted a patent on September 2nd, publication number US 1240-3397B2, and having looked at it a little bit, it is the most professionally insulting patent I have ever seen issued. So, I want to get into that a little bit, but first there's a bit of an overview that needs to be done. So, when it comes to patents, the claims are the name of the game. What I mean by that is that there's a section of a patent called the claims, which is where the inventor is saying, I have invented this is different from what's been done before, and so I'm entitled to rights to this invention. And so they write that out in the claims. For this Nintendo patent, the claim in question is this one. Now, that might not look particularly intimidating until you start to actually read it, because claims are written pretty unintuitively. One of the requirements is that they have to be a single run-on sentence. And that's pretty disorienting if you start reading it like a normal human. So, I want to break this down. I want to chunk it out. But first, I want to give a hypothetical example. Suppose I invented a bicycle, and so I wrote a claim like this. A bicycle comprising a frame with a front wheel connected to the frame and a back wheel connected to the frame. Simple. You understand what I invented. If somebody else comes along after I filed this patent, and they created a bicycle with a bell on it, they're infringing on my patent. Because even though they have more than what I invented, they still meet all of the restrictions that I set for it. I said it needs a frame, it needs a front wheel attached to the frame and a back wheel attached to the frame. That's still true if you have a bicycle with a bell on it. I could sue them for patent infringement if they made their bicycle with a bell. Conversely, if before I filed for my patent, somebody else had created a scooter, that would be a problem for me. Because a scooter has a frame with a front wheel attached to the frame and a back wheel attached to the frame. So even though my bicycle is different from their scooter, the way I claimed my bicycle is the same. And so if that person who previously had made the scooter had filed for their own patent, or they'd used the scooter publicly, or they had printed any kind of publication about their scooter, then my patent is invalid because what I've claimed was already in the public knowledge, even if it wasn't in the public domain yet, even if they still owned it. But I shouldn't have been allowed to get my patent because they already made their thing. I claimed that my bicycle was new when it was just a frame with a front wheel and a back wheel, and actually that's not new, so I don't get a patent. And if I was given a patent, my patent ought to be invalidated. I'm saying that's what's going on with this case, with this specific patent given to Pokemon. They've invented a bicycle when, frankly, bicycles already existed. It's not even as different as they invented a bicycle and a scooter already existed. It really is what they invented already came about. So let's turn back to that claim one, and I'm going to break down what they put forward as their restrictions, as their requirements, what they're saying is new and unique. So this first part, they say that there's this computer-readable storage medium having a game stored on there. The game causes a processor to execute the rest of the instructions. So all this is saying is that it's a video game. You've got a hard drive, you've got a processor. The processor reads a game program on that hard drive, and that causes the processor to execute the rest of what's going on. So that's fairly generic to video game patents. Speaking of generic to video game patents, the next part says performing control of moving the player character on a field in a virtual space based on a movement operation input. That's just saying that you've got a character in the video game that you're allowed to move. Next, they say that the processor is performing control of causing a sub-character to appear on the field based on a first operation input. So there's some kind of input, and then a sub-character appears on the field. Then, when an enemy character is placed at a location where the sub-character is caused to appear, controlling a battle between the sub-character and the enemy character by a first mode in which the battle proceeds based on an operation input. So what this means is that when you summon your sub-character, if it's on the same space or in the same area as an enemy, a battle occurs by this first mode. Next, when the enemy character is not placed at the location where the sub-character is caused to appear, starting automatic control of automatically moving the sub-character that has appeared. So if you summon your sub-character and there isn't an enemy around, your sub-character starts automatically moving around. Simple enough. And then finally, performing control of moving the sub-character in a predetermined direction on the field based on a second operation input. And when the enemy character is placed at a location of a designation, controlling a battle between the sub-character and the enemy character by a second mode in which the battle automatically proceeds. That's a lot of words, but really all it's saying is that the sub-character can be caused to be moved in a direction on the field by a second operation input. Perhaps you move the player character and then the sub-character moves with them. And then when an enemy gets close enough to that sub-character, a battle automatically occurs. That's the whole patent. That's it. You might have noticed this says claim 1. There's 26 claims. I looked through all 26. None of them are very notably distinct from this. There's technical reasons that a patent person might care about how those are distinct, but I promise you don't really care. All the other claims reflect this material. And this material is present in every 3D RPG with a summoner class. So let me break it down as simply as I can again. There's really only 4 unique requirements to this patent. You have to be able to summon a sub-character at a location. If the sub-character is summoned at an enemy location, a battle begins. If the sub-character is not summoned at an enemy location, they start moving automatically. And moving that sub-character by a second operation to a location with an enemy causes a battle to occur. Once again, this is every summoner in a 3D RPG. Specifically, I would say that this is anticipated by the Hunter from World of Warcraft, the Necromancer from Diablo 2, and conjuration spells in Skyrim. All of those involve summoning a sub-character. If that summon is created at the same location as an enemy, they will automatically fight them. For the Hunter, they have to be set to aggressive for that to happen, I'm told. I haven't played much WoW. All of them, the summon will follow you around as you move. All of them, the summon automatically moves around you when there isn't an enemy. And in all of them, if you're moving around and get close enough to an enemy, your summons will automatically start fighting them. So this is just awful. An awful patent. And it's bad enough that I did something I don't typically do. I looked a little bit under the hood to see how the patent examiner decided that this was worth a patent. So a patent examiner is the government employee who gets the application from an inventor and then looks to see what's already been invented and then says yes, no, maybe so, to whether or not they deserve a patent. Here they should have said no. But instead, in their reasons for allowance, they simply copy-paste claim 1 again, and then they say, the player character can be allowed to perform 2 types of battles. A battle by the first mode, in which the player performs an operation input, and a battle by the simpler second mode. That's a terrible explanation. It doesn't distinguish it from any of the games I've already listed. It doesn't distinguish it from a huge number of games. And I typically expect a longer reason for allowance when I see that a patent's been granted. So I looked a little further. I said, well, they had to search the prior art to see what already existed when this game came about. And what I found was their search logs say they searched for 15 minutes. First, they searched for 12 minutes from 5:49 to 6:01 p.m. And then later they did a little bit more searching from 8:45 to 8:49 p.m. So they searched for 12 minutes and they searched for 4 minutes for a grand total of 16 minutes of searching, which is crazy. I generally expect that a patent examiner will be searching for many hours. I'd say anywhere between 4 to 8 hours. And if the patent is going to be granted, if they're going to issue an allowance, meaning they're not rejecting it, they're saying, yes, you get a patent, then I expect the searching to be even longer, because the expectation in patent law is on your first try, you get a rejection. And so here on their first try, they wrote an allowance. And from what I can tell, the patent examiner didn't do much work. So I'm pretty professionally insulted by this level of incompetence. It makes patent law look really bad. And the negative consequences of this are that Palworld or someone else will have to invalidate this patent at some point. Nintendo is entirely able to sue on this patent, and then once it gets taken up by a court, I would be absolutely shocked if the court doesn't strike it down. But typically, patent litigation costs between $2 and $4 million. And this never should have happened. No one should have given out a patent for this. So this is a mistake that has cost the public broadly $2 to $4 million. And it makes patent law look bad, and it really frustrates me. So this is the worst patent that I've ever seen granted. My name is Buck Kansas. I hope you've enjoyed this video. I've decided I'm going to make at least one video on some of the funniest patents I've ever seen, because there is some comedy gold in the patent world. But for now, thank you for watching. Please like, share, and subscribe. It really helps out a lot. Adios.